A Mecklenburg County judge is ordering the man accused of multiple violent attacks in South Charlotte to remain in jail without bond. Daquan Hunt appeared in court for the first time yesterday following his August 6th arrest for charges connected to multiple violent incidents.
He was hospitalized right after he was taken into custody. Now, Hunt is officially charged with assault with a deadly weapon. Videos posted to social media show Hunt allegedly punching and harassing several women in the Dilworth area.
Joining us again now, our chief legal analyst, Khalif Rhodes. Khalif, you know, when you look at the seriousness of the injuries here and you hear no bond, do those things work together? I mean, what does that tell you when you hear a judge say no bond?
I mean, you got a couple things. 15A533, 15A534. Those are the statutes that direct a judge or judicial official, because it could be a magistrate as well, to make a determination on setting conditions for release. One of the conditions for release could be some type of secured bond. The other could be the no bond. Prior to Irena's law being implemented, every charge outside of a homicide case in our state was required that a judge must set a bond. When Irena's law came into place, a number of things changed, specifically the fact that if it was a violent crime, if it was a crime that was involved some type of domestic violence, some type of firearm, some type of violence like this, then now the burden shifts. It's called a rebuttable presumption that no amount of bond, no condition for release, no way would keep the community safe. And so now it shifts to defense having to prove why a judge should set a bond, as opposed to before where it had to be a bond without saying anything. And so I think it's appropriate, based on the way our statute is now written and the laws that are in place, specifically Irena's law, changing it for violent offenses like this.
And so obviously these videos have gone viral. Talking about the assault with a deadly weapon charge, when we don't see a lot of what happens in these videos, right? But are your hands, can they be considered a deadly weapon if nothing else was used?
And that's what I would say, and I would want to see more of the videos. Typically, you're not going to see it when it's just your fist. There has to be some other allegation that it was something other than this fist used, even if it's a phone in your fist, you know, like brass knuckles back in the day in your fist. Something other than your fist has to be a deadly weapon. I mean, most of the time it's going to be, you know, maybe you tried to bump someone with your car, and now your car has become the deadly weapon, but there has to be an instrument outside of your body that is now the deadly weapon to be able to be used for this, because other than that, it would just be an assault charge. But we have other levels of assault, but assault with a deadly weapon would be something other than just your fist.
Khalif, can you walk us through what's happening here in terms of the mental health evaluation? Because we know he was at a treatment center before this and he was released, and that's how he was able to have this court hearing yesterday. Because he was released and then allowed to have this court hearing, now he's in custody, does that mean that the mental health evaluation went which way? Because I'm trying to understand, at what point do you again send him and say, okay, he's fit to stand trial? Does that happen later? Walk us through that process.
I'd say it's the second portion of your statement, that yes, that's something that would happen later. Is he aware enough to understand that he's charged with a crime? That's enough for him to go in front of the magistrate, to be able to be charged, and then go in front of a district court judge or superior court judge, and him to, again, inform him of his charges, allow him to address counsel, and then once counsel's on board, once they're having that conversation, they could say, okay, I've evaluated this person, you know, just on base appearances, based on communication, and I think there needs to be some type of evaluation, a real forensic evaluation. That's a next step, a way deeper step than something that you want at the initial appearance phase, or at your first appearance phase. This is something, you know, you wouldn't determine if they have the capacity to stand trial until you get to that point where we're gearing up to go to trial.
Khalif, quickly, almost out of time. We're coming up on a year of Irena's death. We now have Irena's law. Is this the perfect example of why that law was created and how we're seeing it work in the legal system?
I'd say yes and no. I mean, it is an example that shows that there were a number of failures within our system, both for the mental health component and for individuals coming within the system and in re-entering in pre-trial, not after conviction, but in the pre-trial phase. A person's arrested, they get released on some type of secure bond, and then they commit a new crime while out on secure bond. That is what Irena's law was supposed to avoid. Individuals that have multiple attempts or multiple charges that are similar when setting those conditions, because now you're looking at all the factors. The weight of the evidence is one, nature of the charge is another, but the likelihood of you committing a crime, specifically a new violent crime, if you have a history of 9 or 10 other violent crimes, is increasing. So I think it's directly on par to what they were attempting to alleviate with Irena's law. This is a scenario that I think checks a number of the boxes. And so a great case study for, is it working? Yes, but again, it's a small subset of what's actually happening on a larger scale.
All right, Kali, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.